Hello, everybody. We're going to get started now. My name is Beth Wolfson, and I'm the co-president of the Boston University Art Law Society. This is Amy Noblet, the other co-president. Thank you for coming to tonight's panel, The Art Market, Museums, and the Legacy of the Holocaust, Legal and Ethical Issues. This event is being recorded and will soon be available on the B-Universe website. Please hold your questions until the end of the panel, at which time we ask you to please line up behind one of the two microphones located on either side, and I get to use my airplane movements. I am pleased to welcome Thomas Klein, partner at Andrews Kurth LLP, and assistant professorial lecturer at George Washington University, who will be moderating this discussion tonight. I'd also like to welcome our panelists, Lucian Simmons, senior vice president at Sotheby's and worldwide head of their provenance and restitution research team, Monica Dugo, senior vice president at Christie's and international director of restitution, Victoria Reed, the Monica S. Sadler assistant curator for provenance at the Museum of Fine Arts, Boston, and Sarah Kianowski, assistant curator of painting, sculpture, and decorative arts at the Fogg Museum. I would also like to thank the groups which have graciously co-sponsored this event and without whom tonight would not have been possible. The Career Development Office, which hosted a lovely dinner for the panelists and which greatly helped advertise this event. Andrews Kurth LLP, which helped fund the lovely reception to follow after the panel. Please note that Andrews Kurth has provided us with recruitment materials, which are available at the door and which will be available downstairs at the reception as well. JILSA, the Jewish Law Students Association, CESLA, the Communication, Entertainment, and Sports Law Association, and the International Law Society. I would also like to take a moment to say a few words about the BU Art Law Society, which has organized this event. First of all, Amy Noblet has done a tremendous job in coordinating this event and deserves your congratulations. Secondly, I would like to say a few words about our group. I founded the Art Law Society in the fall of last year, hoping to provide a group where students interested in topics and careers in art law could meet and discuss those interests, and also to provide a creative outlet for students who have a love of the arts. We believe we have met those goals through the lectures we have organized, which include a career panel, a lecture on copyright and new media, a lecture on the Visual Artists' Rights Act by Drew Epstein, who is a local arts lawyer and is here tonight, a lecture on artwork looted during wartime by Thomas Klein, also obviously here tonight. We also organize frequent museum trips, drawing sessions, writing workshops, and an annual student art exhibition and open mic night. If you have any additional questions, please check out our beautiful new website designed by Michael Finnerty, which is available at people.bu.edu/artlaw, or email us at theartlawsociety@gmail.com. Now, without further ado, I'll hand the mic over to Thomas Klein.
Thanks very much, Beth and Amy. I'm very glad to be here tonight. Good evening, everyone, and welcome. Thank you very much for coming, and thanks to the panel for joining us. We're going to talk today about the legacy of the Holocaust, one aspect of it, the current implications of Nazi looting. In order to get to that point, I'm going to give some background, so I hope I don't go through it too fast or have too much whiplash, but you can ask questions later, and members of the panel will fill in little pieces as they go to their aspects of current problems. But what we'd like to talk about today is the impact that this legacy of looting has both on art museums and on the art market, and how people in the profession work and address these problems. I should say, I know students always like to hear a little bit about the people, so let me say I'm a lawyer in private practice, and I've been working on art cases for about 20 years. I happen to be in the right place at the right time, so my career plan worked out very perfectly. I've been doing art cases like some of the things we'll be talking about for a while. So we start, just by way of introduction, with the idea that there was a large backlog, a large history of Nazi and looting. When I say World War II looting, it's kind of a general term, but there was also Allied looting. We won't be talking about that so much today, but there were really thousands of losses. After the war, there was an effort to return art. That's what restitution means, is getting it back to the person that it was taken from, and compensation for losses that could not be restituted. And I'm going to go through that in a little more detail as background for today's issues. Talk a little bit about the law since we're in a law school, but mostly we'll be focusing, I think, on ethical and moral issues and what we might talk about as commercial transactional issues as they affect the art market, the art museum, the museum response, the art market response, and also how claims get handled in this context, which is one of the major concerns today. So we start from the premise that the Nazi art looting was purposeful in the sense that it was connected to the Holocaust, to destruction of people and the liquidating of their assets. So the quantity of looting was truly remarkable and unprecedented. People always talk about, well, there was looting before, but this was really on an unprecedented scale. And then we go to from the quantity to think about why did it happen on this scale. And it was not just to steal the assets of this group of people, but it was to destroy a culture and to build a culture. The Nazis had a very clear, more or less clear idea of some Germanic culture that they wanted to build. They certainly had a very clear idea of the cultures they wanted to destroy. And that was really central to what they were doing and the driving engine for much of what they were doing. Here we see art and power together. Hitler and some of his inner circle with Mussolini looking a little bored, studying art at the Borghese Gallery. Art was really central to Hitler and the things that he was thinking about. And you've probably all heard the term degenerate art, and that's where his program started, with trying to identify what degenerate art was and get it out of the museums in Germany. Had a little trouble defining it. People were trying to understand what he meant. He thought about it as abstract or unfinished. He liked landscapes, things we would think of as kitsch today, romantic portraits. Art by Jewish artists, of course, would be considered degenerate. So a Jewish artist who was a war hero painting realistic paintings, that would be degenerate. German painting modern art, that would be degenerate. Art by Degas, virulent anti-Semite, that was degenerate because it was impressionist, called modern at the time. So even though they had difficulties in definitions and sometimes had fights about particular art, Nazis were very adamant that it had to go, and it came out of German museums. Anybody who's toured in Germany knows that the museums have collections of modern art that they've had to reassemble since World War II, because art that was taken out of German museums and sold or destroyed, well, destroyed, of course, they couldn't get it back, but there have been no claims, no legal claims to recover art lost during this period. It was, the government ordered that it be sent away, and it was. This is a pretty well-known exhibit because it was recreated in the United States not too long ago. This is the Degenerate Art exhibition in Munich, where Nazis tried to build up antipathy for these kinds of works by writing rude things about them as they displayed them. The program then went from the German museums to forcing Jews in Germany and then soon after in Austria to liquidate their assets. This is a property registration form from Austria for a Jewish family, and there are lots of them on file in Austria now. They were forced to register their property to assist in the process of having it be stolen. This is a chart that I hope you can sort it out a little bit. I've tried it recently to see if people could follow it. But this chart was prepared for Adolf Eichmann, who was running the Jewish community in Vienna after the annexation of Austria. So 31 March 1941 is the date of the chart. 2 May of 38 is the Anschluss, and it shows the forced emigration practice, how it was done, starting with 180,000 Jews in Austria down to 40,000 Jews. So this is a key date in Austrian history, March of 41, when they changed over from forced emigration to transports. And this shows the process where the staff of the Jewish community was posting type and explaining how they process people to get all the government agencies involved that needed to be involved to strip people of their assets so they would come out at the end ready for emigration with no assets left. Described by Lynn Nicholas, author of Rape of Europa, as unnecessarily complex and legalistic to make people think that they could beat the system somehow, but eventually people were worn down and had to understand that they could leave only on the Nazis' terms. So the program then started with outright confiscations in Germany and also in occupied areas, always legalistic. For example, there were laws allowing the seizure of abandoned Jewish property. If someone was sent to the camps, their property was abandoned. If somebody fled, their property was abandoned. And there were government organizations whose job it was to seize abandoned Jewish property. If you think then about France and other occupied countries, there was an effort to identify collections that would be seized. One of my favorite cases that I worked on, one of the key facts I always enjoyed was on June 21st or 22nd, the day practically that the armistice is signed. The chief of police of Paris has nothing better to do than to go to the gallery of a German Jewish refugee in Paris and lock it up, sequester it so the fellow can't get his art out. So this shows the very high priority, both culturally, economically, that was placed on art seizures, taking this property. It was policy and program to do it. There were government agencies tasked to do it. In France, it was a group largely called the Rosenberg Action Group, the ERR, which I won't try to say in German, and had at their disposal the army, the embassy, various other organizations that moved from art, in fact, to furniture and other movable property. Very organized. Again, not just something that happened. Supported by law, by government organizations, headed from the top by Rosenberg, who was the ideological leader of the Nazi Party. Now, in the East, there was a lot of destruction as well as looting because the Slavic culture was identified as inferior and to be destroyed, but there was lots of looting in the East as well. And the magnitude, again, in millions of objects, it's very hard to speak in terms of numbers, but more than we can get our hands around. And particularly important for today's purposes, much of the looting took the shape of some kind of forced sale, pressured transactions, where particularly we see now cases involving Jewish art dealers who were forced to sell their inventories, or people who parted with their art to get an exit visa. So not all of the art was taken through a kind of a classic confiscation that you might think about. Now, the Allies, particularly Western Allies, understood what was going on in the occupied areas, and even though they couldn't do anything about it because the war wasn't going very well, they issued this London Declaration in January of 1943, which coincides in time, if you think about it, with the Battle of Moscow and Stalingrad. So that was the high watermark of German military expansion. So the Allies, whether they knew it or not that things were starting to turn around, declared that when they come back, things are going to be different, and they reserved their rights to declare transfers invalid, even if they purport to be voluntarily affected. So they were saying, don't be fooled, we're gonna look at this more closely. But the art looting went on. Part of what Hitler had in mind was to build a huge museum, the biggest in the world, in Linz, his hometown, which he had big plans for. I'm poaching a little bit on my museum colleagues' territory here. This is just a document to give you an idea of the kind of documents that people look at when they're doing research on these issues. And you can see here, for example, I don't know how well it projects, but at the top is the author and the type of art and the dimensions and the material. So there's the families that the art is stolen from is in here. So you would need to put this document together with some other document to try to make it useful in some kind of investigation. After the war, The art that was looted was found in depots. This is a church. This little fella down here this is a person. So we see huge quantities of art collected by the Nazis. We also see, of course, art of the highest quality that they took. This is, you can see from the train, it's in a mine shaft. And the magnitude was so serious that it had to be brought to the attention of the highest level authorities. So here we see again power and art together at the end of the war with the Western Allies trying to figure out what they're going to do about all of this art that had been collected. And one thing they did was set up collecting points in some of the major cities throughout Germany, particularly in the American zone of occupation, bring together this art. That's why I mentioned that word restitution. The process at that point was repatriation, not restitution. The art would go back, would be collected, the stolen art would be collected, and then it would be returned to the country, repatriated to the country from which it was stolen, and then it was the responsibility of that country to return that art to the victims of the theft. One of the biggest problems in Europe today that we don't see in the United States, because we were never occupied by the Nazis, is that these collections were never fully restituted to the original victims. So in the former occupied countries like France and Belgium and the Netherlands, there are still these residual collections that the countries have to figure out what to do about. And they've all formed national commissions and tried to figure out what to do, but it remains a problem in Europe, not so much here. But the solution that was addressed, that was used to address this problem, was U.S. Military Law 59, which became law in the American zones of occupation. British and French had similar laws. And in the other occupied countries, the Inter-Allied Declaration that I showed you became the foundation for positive law in those countries. So those countries passed laws allowing people to void contracts from the occupation period, but there were very short statutes of limitations. So a year or so later, people might not even be home yet. The time for voiding contracts was gone. But in West Germany, Military Law 59 took effect, and it called for the speedy restitution of identifiable property, which means, of course, getting the art back to the victims. And the restitution is appropriate when the art was lost by the persecuted person due to threats or duress, government seizure, or Nazi measures. So it's very broad-based. Confiscation was going to be presumed for transactions within the National Socialist period, and these transactions would be voided. So we have our cautionary blue man telling us, watch out, these transactions can be voided, and restitution is appropriate. This became the law of West Germany. And if sort of like the UCC is a patch on the law, this was a patch on their property law, different from other aspects of German law. And then in the post-war period, this restitution process took a long time. It took really until the mid-60s, because if the art couldn't be found, then the victim rolled over into a compensation proceeding. They had to figure out values for the art. Took quite a long time. And it was really assumed that by the mid-60s, if the art could not be found, the person had its shot at compensation, that the process was really over, that it was finished, done with, people didn't have to worry about it. So we see the latter 60s and really into the middle of the 90s, a period of amnesia, where people just forgot about these issues, they weren't concerned about them, and as a result of the amnesia and the lack of diligence in the art market, these stolen works shuffled themselves around, and that's the origin of our problem in the United States. Again, I said we have no national collection. We have some isolated problems from art seized at the end of the war. There's a document that the State Department doesn't know whether to give to Poland or Germany. There's the Nazi war art collection at the Pentagon that's propaganda. We have some little pieces like that, but we don't really have a collection. But what we have is our major museums, minor museums, major collections. Minor collections are corrupted by art that moved freely with no questions asked through the art market over a period of several decades without people paying much attention to it. And if I had a little more time, I would show you some examples, but the art moved through the market with indications that it was probably looted in the provenance, but without any cause for concern. And then a series of things started to happen in the early, starting in '89 with German reunification and then into the mid-'90s. The first thing, of course, I mentioned to you that this restitution process after the war was exclusively West Germany. Nobody raised their hand and said, what about East Germany? Well, it's, you know, I didn't really expect you to. Well, what about East Germany? They denied being a successor to the Third Reich. They thought they had no obligation to engage in reparations or restitution. So at the time of reunification, a property law needed to be passed to create a procedure and time limits and a standard for compensating people for property claims. And that helped to get more claims started, get people thinking about the process. And Rape of Europa, I don't know if any of you have seen the film, but the book came out in the mid-'90s. It was not intended to be a guide to restitution, but it certainly suggested that restitution would be possible with research. And also some cases started to be brought where people would litigate under existing law, this is my object and I want it back. But I can tell you that as of '95, '96, when I was handling one of the first of these Holocaust cases, I talked to the top levels of the Holocaust Museum and they said, we are not about property. We are about human suffering. We're dedicated to that purpose. We're not going to be involved in property issues. 2 years later, in 1998, they co-hosted the Washington Conference on Holocaust Assets along with the State Department. And again, part of the things that were bubbling to the top by then in the late 80s, I'm sure you remember, is gold, insurance policies, Swiss bank accounts, slave labor claims, forced labor claims, real property claims. So art was part of the mix, and the Washington Principles were adopted by these countries. Now, in 1998, this was all of the countries that had been occupied by Germany and Germany coming to the United States. So it's 42 countries. They all adopted the Washington Principles. And the reason why we could have that level of enthusiasm is that it's not law. They were all afraid of how the principles would affect their existing law. So this is what we call soft law, or if you want, ethical principles. But it has been adopted. It has had some impact, particularly in Europe, and some in the United States, which we'll hear more about from our panelists. But the other point I'd like to emphasize is 50 years later, there is no longer an international consensus in favor of restitution, the way there was in Military Law 59. Now there is a consensus, which Military Law 59 was law, and it called for restitution. Washington Principles, soft law, calls for a just and fair solution. Passage of time, good faith transactions, art moving around, lots of different circumstances have to be taken into account. So this is where the consensus is as of '98, and as we'll hear from people to what degree it still is today, but I think just and fair solution is maybe as good a framework as any for thinking about today's issues. I'm simplifying history a little bit, but for simplification purposes, the Washington Conference did inspire museums in the United States to create guidelines that were efficient and useful. There are two sets, one from the American Association of Museums, AAM, and one from the Association of Art Museum Directors. I'm not the only one that stumbles on that. The AAM is the broader association represents all museums. AAMD, Art Museum Directors, is the major art collecting museums, which are the ones that have the more serious problems. So they both focus on these problems and come up with fairly similar guidelines. I teach with these and work with the AAM guidelines. We may hear more about the AAMD guidelines today. But among the things, we will hear more from our museum colleagues, but one of the things I just wanted to emphasize as a lawyer involved in the area from the point of view of claims handling and museum administration, what the AAM was trying to do was encourage museums, in my view anyway, not to litigate, to try to settle these cases as appropriate. There had been some very contentious litigation, which I was involved in, which showed that the process is very expensive, very difficult, and not very productive. It's better if the cases can be worked out, and there's a big if there, of course. And to do so, the AAM, Association of American Museums, American Association of Museums, get that right, encourage museums to review claims promptly, request ownership information from the claimant, conduct its own research, and share that with the claimant. Now, this seems so basic, so elementary. Well, why did we need guidelines? Well, we didn't just need it because it was a difficult problem. We needed the guidelines because it was a very emotional problem. And it was very helpful to museums to have this kind of roadmap telling them what they needed to do. For example, I was representing an American museum. In responding to claims, I would ask the claimant to provide information, and they'd say, what, are you denying the Holocaust? I said, no, I have to ask for information. I'm required to ask for information. Museums should attempt to settle. Now, this is the really innovative part of the AAM guidelines, which is that it authorizes, which is to say, empowers museums to waive legal defenses if appropriate. Museums had the feeling that they would have to fight every case and be told by a court to give up an object, and AAM felt that in this context, with aged victims or heirs, people who had suffered, museums should be able to exercise their judgment and settle. So it authorized museums to settle cases if appropriate. And the one point I'll make that we may or may not end up talking about more, if we think about this as lawyers for a second, we'll see this is entirely procedural. There are no substantive standards for what is a strong claim, when a case should be settled, when a case should be litigated. So one of the issues today that we see is an inconsistency, and this is not just in the United States, it's in Europe also, inconsistency in how the claims are handled, or at least without enough transparency, it's sometimes hard to tell whether museums are acting consistently or not, because the public doesn't necessarily know all of the facts about a particular case. Maybe we would see more consistency if we saw more facts. So one question for me anyway is whether there's a need for substantive standards today. So today we're going to talk about the current issues. Now I think I got through all that without saying the word provenance, which is the history of ownership of an object, which we use as a surrogate for title, because there is no place you can go, single place you can go to look up title for artwork. It's been historically used largely for authenticity, because if you could track a work back to the workshop, then you knew it was authentic. But it's become a central point for analyzing Holocaust claims and issues. And we'll hear a lot about it today, but I'm not going to try to tell you about it because it's not my field. But what those of us who work in the area do is we try to think about what kind of research is needed, how is that research going to be done. A key question, Tori and I were on a panel, that was our theme, wasn't it? How much is enough? How do you say, how do you know when to say it's done? And then, again, from my point of view, from the museum governance point of view and from representing clients in the area, how do you use this information? What kind of decision making are you going to do? And then how do legal and ethical principles influence decision making, because there is often this tension where you might have one legal analysis and a different ethical analysis. So as Beth mentioned, we have a really terrific panel. I'm really grateful people were able to come. We have Sarah Kianowski from the Fogg Museum, Victoria Reed with a named position from Museum of Fine Arts Boston, Monica Dugo and Lucian Simmons from the Art Market, Monica from Christie's, and Lucian from Sotheby's, all people who work day to day in trying to solve these problems. So we will hear about some of the details of how they work, but really their jobs, from my perspective at least, are problem solving. So with that, I'd like to turn things over to Sarah, who in many ways symptomizes the people who got caught up in these issues, has a terrific 25-year history with art museums and galleries, And yes, am I not supposed to say that?
I think you're right. I just never thought of it that way.
You know, people say I went to fact school, not law school. You know, and what impressed me about Sarah, who I've just met tonight for the first time, is that she writes extensively in the art history area, but is willing to speak in this area, not so much write about it. But Sarah's very well known for her work in this area, both in the art area and the Provenance area. So I'd like to turn things over to Sarah from the FOG. Oops. I'm gone.
That's mine.
That's you. Oh, you're there.
Right, yeah.
All right.
Looks like we're all set. Thank you, Tom. As I said, I'm the assistant curator of painting, sculpture, and decorative arts at the FOG Museum. My department there is responsible for works of art made mostly in Europe from the end of the classical period until 1900. But for the first 5 or 6 years I was there, we were also responsible for 20th century art and contemporary art. So I have a pretty broad knowledge of the collection. I came to the FOG from the Art Institute of Chicago, where I cataloged drawings for 3 years. So I had a lot of experience in cataloging. And I spent my first few years as an assistant curator at the FOG planning new installations, writing grants, and doing research on objects in our permanent collection for a pilot project to catalog our 19th century paintings in an electronic database. My familiarity with the collection meant that when interest in the whereabouts of the museum collections during the war years became an important concern in the late 90s. Now, where's my slide? I thought it was here. There it is.
You need to right-click on it.
Right-click on this?
No,
No.
excuse me.
Sorry.
I can get that for you.
Okay, thought we were there already.
There you are.
Sorry. This was my introduction to the world of provenance research, I'm afraid. This is an article that was in the Boston Globe. Above the fold, Sunday, full color, 2-page spread in the inside, 4 paintings from the FOG Museum and 4 paintings from the MFA. And that became my new responsibility because I had just finished this collections database. So to go back to the museum, though, the primary mission of an art museum is to preserve, document, present, interpret, and strengthen its collections. In traditional museum practice, this has meant acquiring, researching, and writing about works of art, creating exhibitions to present and interpret them, and acquiring new work to expand the collections. When a new work comes into a museum collection from private hands, it can be studied, exhibited, and enjoyed by the public. By the same token, when an object is removed from a public collection by deaccession or because it needs to be returned because of a claim, the public loses access to that unique work of art, and the public is diminished. Through its designation of museums as charitable organizations and as 501c3, giving us 501c status, our society indicates its belief that the entire public benefits from the activities and existence of the art museum. So museum staff and trustees have a duty of loyalty to the purpose of the museum and a duty of care to the objects. And both of these duties extend beyond the tenure of any individual museum staff person. These obligations to the work of art are very different than the obligations of private collectors who don't have any responsibility to the public, or commercial interests such as dealers and auction houses whose successes are counted by the objects that leave their care. This brings us to one of the primary tasks of the museum, acquiring new works for the collection. Our new exhibition process document, which is about to be approved, if I'm lucky, states, the museum will adhere to a thoughtful acquisitions policy that limits new accessions to works of substantial value for teaching and research. Stewardship of collections entails the highest public trust and carries with it the presumption of rightful ownership, care, documentation, accessibility, and responsible disposal. All objects that enter the collection must be acquired in accordance with state and federal law, university guidelines, ethical standards, and professional practices and procedures, end quote. But how do we select the works for acquisition? By far, the majority of the works that are offered to us as gifts or bequests. I know we have the name Harvard over our masthead, but we actually don't have a lot of money to spend on art. So only a minority of the objects that come into our collection are purchased either from dealers or from auctions. But we do not and cannot accept every object that's offered, because even an object acquired as a gift consumes resources in terms of its study and care and even the cost of storage. Like most museums, curators at the Harvard Art Museums create collections plans that analyze the existing collections and then identify areas in which the collections might be strengthened. So for example, the collection for which I'm partially responsible is very strong in late 19th century French painting, Impressionists and Post-Impressionists. We're really weak in early 19th century French landscape. So we'd be unlikely to buy or even accept a sort of middle-of-the-road Impressionist painting if someone offered it to us, because we have a lot of them. But if we had an opportunity to buy a really great, Valenciennes sky oil sketch, we'd jump on it if we could find the money. But all of these are things that we have to think about when we're doing acquisitions. Along with investigating the stylistic and philosophical underpinnings of the artistic endeavor, provenance research, which, as Tom said, is establishing the history of ownership, is an integral part of understanding the works in our care. Research efforts on provenance can be divided into sort of three separate efforts. Research completed as a prerequisite for new acquisitions, research into existing collections for exhibition preparation and collection cataloging projects, and finally, short-term research, which might be undertaken in response to loan requests, proposed deaccessions, and in rare occasions, in response to claims. Provenance research has several purposes in current museum practice. It helps the curator to confirm that the object is what it purports to be. This might be harder than you might imagine, but unlike a piece of property which can be described by geographic location and measurements, works of art can be hard to describe in a unique fashion. For example, this is an oil sketch by Corot that we received as a gift in 2002. He painted hundreds of these. They're all around the same size. So if you look at an inventory and it says Corot and it says Italian landscape, there's no way to know if it's this one or another one. And so just identifying something can be much more difficult than it is in other areas of the law. Establishing the chain of ownership has long served as a way of authenticating works of art based on what's known about the collectors. One might be more suspicious of the authenticity of a 17th century Dutch painting whose ownership can only be traced to 1920 than one might be of one which can, through looking through old correspondence, be located in an English manor house in the 18th century. On the other hand, sometimes you can trace an object almost back to the hand of the artist and still be unsure about its authorship. This is a still life with birds, which has been attributed over the course of time that we've had it, which is since the mid-20th century, to Paul Cézanne, to his friend's son, Paul Gachet, to the artist Guillaumin. If you look at the database that we keep of these objects, it's got 6 different authorships in it over time, and that's one of the things that we track. The painting actually belonged to Paul Gachet, who was a friend of Cézanne's, so it's a lifetime connection. Unfortunately, we also know that Paul Gachet's son, who inherited his collection, painted some things himself. So even though the provenance has allowed us to get this object all the way back, we still can't be quite sure of what it means for us. Research into previous ownership can also illuminate the history of taste. And I give you here the Van Gogh self-portrait. This painting was purchased by Hugo von Tschudi in 1906, and he was a curator at the museum in Berlin. He bought it for the National Gallery with money from sponsors because he didn't have money from the museum itself to buy it. But he didn't submit it to the Kaiser for approval. And one of the things to remember is that European museums are generally national institutions, whereas American museums are mostly privately run institutions. So in European museums, if the Kaiser says no, the painting doesn't go into the collection. So von Tschudi kept the painting himself. And when he moved to the Neue Staatsgalerie in Munich, he brought it there, and it was exhibited there. When he died, he left it to his wife, and she eventually sold it to the Neue Staatsgalerie in 1919. by which time Van Gogh was recognized as an artist that one would want in their museum. The painting stayed there for 20 years until 1939, when it was declared degenerate and was sold in the sale of Degenerate Art in Lucerne, Switzerland, and was purchased by Maurice Wertheim, who eventually gave it to us. So again, it's a provenance question, and it's even a World War II provenance question, but it really tells us much more about the vagaries of style and taste in Germany than it does about whether or not our ownership of this painting is clear. And as Tom said, because this was a piece of national property that was removed from the museum by that government, the German museums haven't made a claim on this. In fact, we lent this back to the museum in Munich for an exhibition in honor of Hugo von Tschudi about 10 years ago. Proper provenance research can also prevent a museum from incurring a fiscal loss by acquiring an object it can't keep or would have to spend money to keep. We had a group of pottery shards that we spent hours and hours and hours talking about in curatorial meetings at the Harvard Art Museums before we acquired them, because we weren't sure whether or not we'd be able to keep them. And in fact, we kept all but one. We bought them, we published them, and then found out that one of these pottery fragments belonged to a vase that was in Geneva, and we just sent it to them, and they popped it back into the vase. But we can also prevent the donor of the object from incurring a loss. If an object given to the museum is later deaccessioned to return to a World War II claimant, it's possible that the donor could be liable for the amount of the tax deduction that they received at the time of the donation. Careful provenance research also protects the works that we hold in trust for the public from being given to private individuals or returned to source countries without proper documentation. Even in the case of a work of which we were only temporary custodians, such as this Malevich that belonged to the was on loan to the Busch-Reisinger Museum, this painting was actually left in trust by a man named Alexander Dorner, who had known Malevich. And once they were separated by the war, and he was separated from Malevich's heirs, he brought the paintings that he had with him to the States, and he gave this one to the Busch-Reisinger Museum with the caveat that they should eventually give it to Malevich or his heirs. It took years and years to properly identify the artist's heirs, because there were 31 of them. And they all had to be properly identified before the object could be returned to the family, to make sure that all of the people who ought to benefit from the return of the object were properly doing that. Finally, and this is something that really pertains mostly to university museums, careful provenance research and careful choosing of objects is really important in protecting the research interests of our colleagues elsewhere in the museum. And this is something that pertains more to cultural property, but cultural property and World War II provenance overlap a lot, at least in my life. And our colleagues who work in digs in Turkey or in Greece, if we acquire something in violation of one of those countries, we could impair their ability to go back and continue their research. And so that's another thing that we have to keep in mind. Finally, by demonstrating care and making additions to our collection, we help to maintain the public's trust in the museum's ethical stance. And because we're often telling people that things are worth looking at or worth spending money on, we need the public to trust us. Otherwise, we can't do our work. Accurate provenance research involves understanding of art history, the history of collecting, and now it turns out the law. We follow a number of outside recommendations and guidelines, including the AAM guidelines and the AAMD guidelines. We also follow the UNESCO Convention on the means of prohibiting and preventing illicit import and export. All of those are things I've had to learn about in the last few years. These guidelines all recommend additional research if an object may have changed hands in Europe after 1932, and it suggests going beyond the information provided by the vendor or the donor. And the AAM says, in the absence of evidence of unlawful appropriation without subsequent restitution, the museum may proceed with the acquisition. The AAM handbook, which is published in, is it 2001? provides more direct instruction on how to conduct provenance research. It gives lists of archival sources and ways to find the information that you need. One of the things that's really changed in the time that I've been doing this work is when I first started, the documents that were in Washington from those teams of servicemen that Tom told us about were really just becoming available to the public. A lot of documents were actually not available until that point. And then, of course, with the advent of the internet and computer databases, there are things that I couldn't find out 10 years ago that now I could find out without leaving my desk. So it's really changed a lot just over the course of the time that I've been doing this. But none of these documents really provides prescriptions for how to conduct provenance research or how to know when you've done enough. At the FOG, as at most institutions, curatorial departments are responsible for completing provenance research before we propose a new acquisition. And then in our discussions about whether or not to acquire something, questions can be raised about that. And we're currently developing a new, even more prescriptive policy that should lead to more consistent record keeping. Provenance research begins with the existing history provided by the donor or the dealer. We have some leverage with vendors to get information from them since they have an interest in selling. But we have there's less pressure we can bring to bear on donors or estates. Often the documentation is simply gone. And most of the time the burden of the research falls to the receiving institution. The exhibition and publication histories can sometimes fill in more information for us, as can auction house records and dealer archives. For museums in large cities or those associated with the university, this can be done locally. But for many others, it involves travel to libraries in other cities. And you can imagine that for small museums, this can be an enormous expense. And it makes it really difficult. A lot of the small university museums that might have a handful of paintings that are what the AAM calls covered objects, it's very hard for them to get this work done because they simply don't have the budget. We can also examine, in addition to all of the archival sources, we examine the object itself for marks, labels, and inscriptions, and evaluate whether they corroborate the existing history, enrich it, or contradict it. And this is a Barye sculpture in our collection, and that stamp underneath tells us that we know that it was sold at the Jerome Stoneborough sale in London, but we weren't sure how or when it left Austria. This is an Austrian export stamp from 1939, and so now we know that it left. His wife took it out when she went to sell it. We're often asked how much research is enough, and the problem is that it can be really difficult to know. In the case of this Monet portrait of Eugénie Graf, we might easily have made a mistake had we not persisted with our research. Had we stopped with the family's initial asset report, and this is another one of those 1938 Austrian asset reports for the family of Paul Wittgenstein. In fact, this is his document, even though he was living in the United States at this point. We might have made a mistake. This document was provided to us by the Boston Globe. In that article that I showed you the headline of, they suggested that this painting had been looted because this document existed. They made the leap from the family having filled out the asset report to assuming that it had been looted. And we knew that it had been sold at a gallery in Stuttgart in 1955, and it was a gallery that was known to have sold some looted art. And so they made, a not completely unreasonable jump. However, later documentation also provided to us by the Globe, but not published, showed that the family actually succeeded in getting themselves reclassified and were able to keep their property during the war years. What happened is that the Wittgenstein family's grandfather was Jewish, only one of their 4 grandparents, and that's all it took for you to be classified as Jewish. And the family was trying to get themselves classified otherwise so that they didn't have to leave and they didn't have to give their things away. And they split into sort of 2 factions. One set of cousins said, our family can't possibly be Jewish. Number one, our grandfather didn't act Jewish, and he didn't look Jewish, and we were all baptized, and oh, by the way, his mother had an affair with a traveling actor, so the man who raised him as his father isn't actually his father, and so he's not Jewish. The other half of the family, the more successful half, basically offered some of their stocks, and that was enough to buy a new designation for their family. And so they actually held on to all of their property through the war. His 2 sisters stayed in Vienna in the family home, and they still owned it, and he exported the painting after the war. I'm often asked how this work is funded. Unfortunately, while the Washington principles give general recommendations for a course of action, no funding accompanied those standards. And that's as opposed to something like the NAGPRA situation, which is the ruling that museums have to return materials to Native American tribes. Federal funds were made available to assist museums with NAGPRA returns and with doing all the identification. There's no federal funding available for this work. Provenance work is often folded into the existing responsibilities of museum staff. For the first few years I did it, I simply took every courier trip to Washington that the museum had. Every time we sent an object to an exhibition, I took the trip, I sat in the truck, and that way my trip was paid for, and we could just pay for an extra for a hotel room for one night, and I could get a day of research in and try and figure things out. The situation's even more complicated when the research is in response to a claim, because then you really have to rush. I mean, most of my work is sort of proactive. I'm taking a slower approach to our collection and trying to be methodical about it. But when there's a claim and the threat of legal action, you have to work right away. Museums have to hire outside counsel and outside researchers, often at great cost. And these expenditures are unlikely to be recouped, even if the research demonstrates that the claim was unfounded, as in the case of this Van Gogh, The Diggers, from the Detroit Museum of Art. In this case, the heirs of Martha Nathan attempted to claim 2 works of art based on the fact that she had left Germany and that the paintings were sold in 1938, and so they assumed that these were forced sales. The museum hired an outside researcher who was able to show that the paintings were not sold under duress. And when the claimants continued to press their claim, the courts eventually found in favor of the museum based on the statute of limitations. So that's one of those defenses that the museums are encouraged to waive. And the museums would have been happier if the decision had been made on the facts, because the facts also supported the museums keeping the paintings. But the courts make the decision based on the more legalistic arguments. Which, you know, for those of us who spend all of our time doing this research is really just incredibly frustrating, because we have all of this documentation and they're just not interested sometimes. I would imagine that the services of the outside counsel for 3 years, as well as the cost of hiring an independent researcher, would have reached well over $100,000 for these 2 paintings. So there was another painting in this case at the Toledo Museum, and they worked together on it. In legal terms, that might not be a lot of money. In museum terms, it's enormous. It's a couple of exhibitions, or 2 or 3 publications. It's a really big expense for us. As I said, my experience at the FOG has been one of careful, proactive research into the collection, punctuated by the occasional excitement of an outside query. But we've yet to go to court for a claim, nor have we found any object that needed to be returned to its pre-war owner or their heirs. To cover those thornier matters, I'm happy to turn the microphone over to my colleague, Victoria Reed.
Well, thank you very much, Sarah. That was a great walk through a lot of territory, very thoughtful, very helpful. And let me introduce now Tori Reed from the Museum of Fine Arts, Boston. She is the Monica S. Sadler Assistant Curator for Provenance. Tori and I first met 2 years ago when we were on a panel together I was mentioning for an AAM conference here. Tori has an art history background with a PhD from Rutgers. She writes and speaks frequently on art historical and art provenance issues, and I'm sure you'll enjoy hearing from her on the perspective she has from her work at Boston Museum of Fine Arts. Tori.
Thank you. My job as the provenance researcher at the Museum of Fine Arts is to examine the history of ownership of the objects in the collection and in particular, to determine where they may have been between 1933 and 1945. Were they, for example, in the hands of Jewish collectors or dealers whose persecution by the Nazi regime led to lost or stolen assets? I look for what we call red flags, which may signal theft or invalid transactions, including seizure by Nazi authorities, sales that took place by force under the Nazi government, and deals in which sale proceeds were never realized. I spend time researching such high-priority objects to better document them, with the goal of answering questions about their wartime whereabouts. In the event that a restitution claim were made for one of the objects in the collection, I would work to collect as much information as possible about its provenance, which would ideally assist both parties, that is the MFA and the claimant, in resolving the ownership issue as amicably as possible. Now, I presume that my colleagues at auction houses and art galleries, as well as independent provenance researchers, undertake similar research in their respective roles. Yet, while the process of conducting provenance research may not differ greatly from museum to auction house to private collection, in my work, I confront issues that are specific to museums and that have a direct impact on the implementation of our shared research methods. These three issues, which I'll discuss briefly this evening, are that museums, first of all, have permanent collections. Second of all, uphold standards of accessibility and transparency to the public regarding their collections. And third, are subject, as public institutions, to public visibility and scrutiny in their actions. To the first point, talking about permanent collections, most art dealers and galleries do not have permanent collections of paintings and sculptures. Rather, their objects are held temporarily, bought or accepted on consignment in order to be sold. So if an auction house or a gallery or a dealer is considering a work of art, any questions about or gaps in that object's Holocaust-era provenance may well deter them from handling the object. But in contrast, the MFA has a collection of works of art that were acquired between 1876 and the present that it is my job to research and document. In the Art of Europe department, for example, this includes some 1,500 paintings and works of sculpture and decorative arts numbering in the thousands. If a commercial gallery can choose to turn down a work of art based on unanswered questions in its provenance, the museum cannot retroactively reconsider an acquisition or go back in time to demand more documentation from a dealer in, say, 1950. So I deal with complicated provenance issues on a daily basis. I know that in any collection of objects, there are going to be gaps in provenance, dead ends in research, and questions about ownership that can never be answered. In fact, an unbroken provenance is really the exception rather than the rule. And there are various reasons for this. The physical evidence documenting ownership, including receipts or inventories or photographs, may no longer exist, or they may never have existed to begin with. The painting or sculpture may have been in private hands for a long period of time and was simply never documented publicly, as in a book or exhibition catalog. And previous owners pass away, or if you can contact them, their memories may be faulty or incorrect. For example, in the collection of the MFA is this 14th century Italian painting by Barnaba da Modena. And you'll see that the museum acquired it in 1915. We don't know where it was before 1914. And the information that was provided to us by the previous owner, Robert Langton Douglas, about it being in the Fuller-Maitland collection can't be verified. And I've tried by looking at the secondary literature on this collection as well as inventories. And it may not be correct information. So does this mean that this has a suspicious provenance? Does this mean that there are problems with the ownership history of this painting? Well, not necessarily. It simply means that we have a lack of information about where it was. But suppose you were looking at this and you saw that the museum acquired it in 1945, and we didn't have any information about where it was before 1944, and the information that we got from the previous owner turned out to be incorrect. Would we regard it a little bit differently? Would we look at it as being suspicious? I think that we might, but we shouldn't necessarily, because it's the same set of issues, the lack of information, that can occur with an object acquired in any decade, whether it's 1915 or 1945. So provenance research in a museum collection is really full of dead ends, and a gap or even a suspicious name in a provenance does not necessarily signal a problem. The issue of transparency is also key, and I've put up here a couple of points from the American Association of Museums recommendations for providing information to the public. In keeping with its internal policies, as well as the ethical guidelines issued by the AAM and the AAMD, museums like the MFA maintain for the public access to their collections in our galleries, in our storage spaces, and in traveling exhibitions, as well as transparency about our research and documentation. And this, of course, includes provenance research and provenance information. Now, as a larger museum, we're very fortunate to have a strong web presence. The MFA maintains an online database of nearly its entire collection. You can see, you can search. And each object record, there's an example here, is accompanied by a description, dimensions, an image, and provenance information whenever available. And the website is actually updated nightly so that any changes that are made to our internal database show up online the following day. We also have a page of the website that's devoted to paintings, sculptures, and decorative arts that may have particular problems during the Holocaust era. And in this way, we hope to draw attention to our most pressing unanswered questions in the hope of bringing in additional information from others. To facilitate this, we actually have an email address specifically for provenance questions. Now, greater visibility in this way can lead to an increased number of restitution claims, which take a great deal of time, as Sarah said, to resolve. But nevertheless, I think transparency must be the goal because it does provide broad access to the collection. It helps to educate our viewers. And in terms of provenance research, it can really be the key to identifying works of art that may be missing or that were stolen. This is a small Madonna and Child painting that the MFA had purchased in 1970 on the German art market with no knowledge of its earlier history. It appeared on our website pretty much like this at the beginning of 2004 with only the dealer's name. But in early 2004, a French graduate student who was working on reliquary triptychs contacted us regarding this work, which she had found in a turn-of-the-century Polish exhibition catalog where it was illustrated as the central panel of a little triptych in the collection of Tadeusz Konopka of Krakow. Now, I didn't know who this person was or the significance of his name, but I updated our provenance information, the record that went online, with his name and his city, and the date, which was 1900, 1902. And we were, within just a few months, contacted by the Polish embassy about the work, and they identified it as being the central panel of this triptych that was taken from the home of Konopka's family during the Warsaw Uprising of 1944, in which time it was separated from the side panels and has subsequently been lost. And the central panel was lost until it showed up on the art market in 1970. So when the museum received the documents from the embassy regarding the wartime losses of the family, they decided to deaccession the work and return it to Konopka's granddaughter in Poland. Now, in this case, I would never have been able to work backwards, given what I knew, to this small private collection during World War II. The only way this work of art was able to be identified was through our website. Which brings me to my third point, which is visibility, and in particular, visibility and press coverage. Because museums, unlike private collections, are open to the public, and we're here to serve the public interest. Our collections and the issues that surround them, which, as we've already discussed, are both complicated and transparent, assume a high profile. And the local and national press keeps track of museum practices and legal cases, which are often the subject of scrutiny. Issues of provenance research and any restitution claims filed in court are presented in newspapers and journals as news stories for the lay reader, and the facts of the case are often simplified to the point where there is very little nuance, examples of which you see here. By overlooking the fact that these issues are truly complicated and lengthy, journalists often present museums as intractable and slow-moving institutions, when in fact it's usually the museums that are doing most of the research. It will come as no surprise to at least some of you that the MFA has been involved since January in a court case regarding the ownership of Oskar Kokoschka's self-portrait with Alma Mahler, which you see here. Now, this case is still in litigation, so I have to keep my remarks this evening brief. But the basic facts of the case are as follows. Around 1914, the painting was purchased from the artist by Oskar Reichel, who was a Jewish art collector in Vienna. In early 1939, he handed the painting over to Otto Collier, a Jewish dealer who had recently left Vienna for Paris before immigrating to the United States later that year. Collier brought the painting with him to the US, gave money for it to Reichel's sons, who had immigrated earlier in the decade, and later sold the painting on the New York art market. So while the painting was never in Nazi hands, it was not literally sold by force, or the proceeds withheld from the Reichel family, the question arises of whether the circumstances of the transaction were such that they should be invalidated. Along these lines, the claimant, the designated heir of Oskar Reichel's last surviving son, has asked for the return of the painting. Now, the case does not deal with Nazi-looted artwork or a government forced sale, but instead how to correctly assess the amount of duress that went into a transaction that took place nearly 70 years ago. For a year and a half now, research has been ongoing into the two individuals, Reichel and Collier, their relationship, the fate of the Reichel and Collier families during the Holocaust, the post-war history of the individuals involved, and the painting, not to mention the role of the artist himself and the market for Austrian expressionist works here and abroad. So I'm not going to go into any further details about the case itself, but you understand that this is far from simple. Now, the Boston Globe has run 2 articles on the Kokoschka claim since the initial complaint was filed earlier this year. The first, in January, distilled what was at that point 9 months of intensive research, and you can see the article is pretty long, into this one short paragraph, and then solicited comments on the outcome of the case online. At least 15 people registered their opinions. A second article in May, at which time no further developments in the case had been announced publicly, sought out the opinions of the claimant's attorneys and those individuals who had, for one reason or another, publicly supported her side of the case. Now, reporters, scholars, and the public are, of course, free to come down on one side or the other. The museum's visibility and its status as a public institution invite this kind of analysis. But from my perspective, as the researcher, what's lamentable is the false impression that such stories give, that these cases are very cut and dried and very easily summed up. As well, neglecting to go into some of the more complicated documents that are publicly available, such as the court filings, have led to factual errors in the press coverage. These errors have only furthered the misunderstandings about the research at hand. So I myself would argue for a more nuanced presentation of the facts, no matter what the opinion of the journalist or the newspaper. In conclusion, museums must deal with tracing the complicated, often unresolvable Holocaust-era provenance questions surrounding works of art in their collections. If visibility and transparency seem to invite complications at times, they are nevertheless necessary to fulfilling our roles as keepers of the public trust and in bringing about resolutions to ownership questions and disputes. Museums need to work together with potential claimants, and inviting their questions, input, and additional information can only help both the claimant community and the museum community ensure that works of art are in the hands of their rightful owners. Thank you.
Well, thank you, Tori. It's pretty clear that's the voice of experience speaking. I'd like to now introduce Monica Dugo, who also has a great deal of experience in this area. She is presently International Director of Restitution and Senior Vice President at Christie's. She came to this position from the Holocaust Claims Processing Office in New York, where she both represented claimants and tried to settle cases. So Monica, trained as a lawyer rather than in the art historical background, has had a great deal of involvement in these issues. We first met during the run-up to the 1998 Washington Conference that I mentioned, so also a voice of wisdom. So Monica, I've asked Monica to talk a little bit about what she was doing at the HCPO and the perspective of claimants, and to talk about what she does now in the context of the art market. So please, Monica.
This one, right? No, well, I don't know. It's F5 or this, I think.
What? But
No,
to
just
change
down
slides.
now.
Just this one.
Yeah,
Okay. Thank you. Sorry. Thanks for the invitation to come and speak here today. I've been coordinating Christie's restitution issues worldwide for about 4 years now. This means overseeing our research into objects consigned to us for sale across our offices and sales rooms worldwide, working in resolving restitution issues where they arise, and also working with claimants and their representatives. As Tom mentioned, before joining Christie's, I was for almost 8 years Deputy Director of New York State's Holocaust Claims Processing Office, an office set up in 1997 within the State Banking Regulatory Agency. There I assisted claimants in seeking to recover art collections and other assets lost or looted during the Nazi era. And the aim was to resolve claims in a fair and non-litigious manner through dialogue and open exchange of information and cooperation. While there, I worked on roughly 120 art claims, recovered 14 works, and resolved a number of others. These included claims ranging from a Lucas Cranach Madonna and Child at the North Carolina Museum of Art, as well as other paintings and drawings from other European collections and foundations. Resolving art claims while at the Holocaust Claims Processing Office was facilitated to some degree by an expansion of the legal framework since 1996 through Holocaust-era asset litigation, specifically the class action lawsuits in the latter 90s against the Swiss banks and the insurance industry that Tom mentioned, and through non-binding guidelines on how to handle Nazi-looted art drawn up at the 1998 Washington Conference on Holocaust-era assets. While transfer of property from Jewish collections was declared invalid by the Allied and various post-war governments, and this presumption forms the basis for international understandings like the Washington Principles, as Tom described, there is no clear and binding law that governs restitution today. I should note that while claims into recovery of assets from banks, the insurance industry, or in recognition of slave and forced labor are relatively clear-cut in where the fault and responsibility for compensation lies, the question for art recovery is far less straightforward. Looted art will have passed through many hands over the past 70 years and is often difficult to trace. These cases are very fact-specific, and resolution of Nazi-era claims can depend on a myriad of factors, which include in which countries the picture changed hands, whether the painting is located in private hands or in a public institution, in what nation or state the object is actually found, or whether one can even trace the heirs. This evening, I'd like to talk about the challenge restitution presents for the art market, and to give you an insight into how we deal with looted art when we come across it, how the art market has contributed to both the problem and the resolution of Nazi-looted art, and some of the difficulties we all share in identifying such art, and we've heard a bit about this already. As Tori mentioned, auction houses are not in the same boat as national bodies or museums charged with overseeing collections. We do not own or very rarely have a financial interest in the objects that we are selling. Our lots are owned by our clients, and our work in this respect is to act as an intermediary between current holder and claimant. As Tom has described, the widespread looting which happened during the 12 years of Nazi dictatorship and during World War II amounts to the greatest theft of art ever known. While it's difficult to estimate exactly how much art was affected, some estimates, sorry, I didn't mean to do that. Some estimates suggest that about a fifth of all art in Europe was spoliated or displaced during this period. Hundreds of thousands of works of art. The theft of vast quantities of art was an official policy of the Nazi government, and the scale and the scope was unprecedented. To put the approach of the modern commercial art world into context, I'd like to first step back a little bit and look at how the art market contributed to the circulation and dispersal of looted art, even from the early days of Hitler's regime. With the world economic crisis of the early 30s, the years of political uncertainty, and then the outbreak of the war, the art market in Europe had been somewhat in the doldrums. However, the war and Nazi looting policies did nothing to depress it further. In fact, it was quite the opposite. The voracious appetite of the Nazi high command for art and the sudden influx of quality collections on the market fueled demand regardless of its source. And even before the war, keen-eyed dealers and collectors looked out for fresh works, hoping for bargain prices coming from forced sales of Jewish collections. But after 1940, prices in occupied countries like France and the Netherlands rocketed, fueled by leading Nazis and their agents who were willing to pay well for the type of art that they wanted, and by the canny dealers who thought to take advantage of the situation. Added into the mix was a myriad of often competing Nazi looting agencies, from the ERR to the embassy in Germany, and Tom touched on this. This only exacerbated the situation. Amsterdam and Paris boomed, and neutral Switzerland certainly profited as basically a clearinghouse from the trade in looted art. And alongside this, the direct confiscation of collections, Aryanization of businesses, a layer of keen dealers and middlemen happy to grease the wheels of Nazi acquisition, all of this served to obscure provenances of these paintings. You only have to look at the number of names that are included in the final report of the Art Looting Investigation Unit or the Nazi inventories that, again, Tom had discussed, to get a sense of the network of people and dealers involved in the displacement of art. In the war's aftermath, it would have been a confusing melee of misinformation and frustrated claimants. Broadly speaking, while some works of art did find their way back to rightful owners, a significant number did not. And as we've heard, post-war efforts in the chaos of the few years after the war failed on a broad scale to redress the wrongs of the Nazi era. In a way, this was inevitable, with Europe's cultural treasures comprehensively plundered, scattered, the radical redrawing of drawings, the wide diaspora of Holocaust survivors and victim families. However, where it was possible to match recovered works to their owners, many cases were harshly judged. And we've seen this legacy impact on the new work on restitution taken on in the last few years. Indeed, thousands of looted works, and we've all heard about this evening, still remain unaccounted for. Items from pre-war collections can surface in the hands of dealers, governments, collections all over the world. Nazi looted art continues to be passed on, often inadvertently, as these displaced works pass from one hand to the other or are passed on through the art market. So what does the legacy of the Nazis' policies towards objects mean for an auction house like Christie's? In fact, restitution has become one of the most challenging issues facing the commercial art world today. As a result, Christie's, along with other organizations, plays an important role in identifying looted art and resolving Nazi-era disputes. Christie's, in common with other high-profile auction houses, is perhaps the most visible and public part of the art market. There's a constant flow of works that pass through Christie's doors, about 200,000 objects a year, and we're often on the front lines when restitution issues come to light. This makes it inevitable that we're going to come across looted works of art. As a result, we're actively involved in due diligence work and have developed internal tools to help in identifying problematic works. For instance, we've developed a database of red flag names to look out for in provenances, and we currently have 13,000 logged of either people and collectors who are victims of spoliation, perpetrators of such spoliation, middlemen and associates who've been known to be involved or who have known to have handled looted art. Such names prompt further research, which can help to uncover the story behind the provenance and also to fill in critical gaps in published resources. In addition, we work closely with claimants the restitution community, archivists, historians, the Art Loss Register, to try to identify potentially problematic objects. Some of the spoliated objects we've seen over the years, as shown here, are quite varied. And while the majority of artworks come from Jewish collections, we see other examples of spoliation. The Kirchner that you see on the top left was stripped from the collection of the Städtischen Museum in Dresden because it was considered degenerate. And the painting by Cornelius van Haarlem of Hercules and Aeschylus, which you see on the top right, was confiscated by the Stasi from its owner in the then East German part of Berlin. For years it hung in the Gemäldegalerie Gallery and then the Bode Museum in Berlin until its restitution earlier this year. Other works come from the restituted collection of Eugen and Fritz Gutmann, prominent Dutch collectors. And here you have another picture of the Van Haarlem, another image. What we sell and how is under constant examination. In addition to potential buyers seeking the reassurance of a clean bill of health, if you will, before investing their money, claimants, our representatives, and advocate organizations also pay close attention to the art market. Our primary aim, underpinned by research and internal resources, education, and company-wide awareness of the issues, is to make sure that we do not knowingly sell looted objects. However, even with the rapid increase of information on looted art over the last decade, which we heard about, and despite careful precautions not to knowingly sell looted objects, it's often very difficult to identify looted art. Firstly, while the Nazis often documented looted works of art, when part of an orchestrated campaign of dispossession, the looting of hundreds of thousands of works sold or exchanged under duress, or the confiscation of modest works may never have been documented. Secondly, there's no single repository for information on looted art, not one single database or source on what was taken from who, how, and when. Thirdly, while the provenance of a work of art is clearly all important in today's art market, tracing the history of a work of art is anything but straightforward. And Sarah talked about this. And until recently, provenance was only interesting to dealers and collectors if it added a little something to a cachet, to the cachet of a work of art, a prominent collector, or to prove that it wasn't a fake. Fourthly, archival information, dealers' records are not always accessible. And finally, there are gaps and mistakes in available publications, all the publications that we use. And furthermore, paintings executed hundreds of years ago may have changed attribution several times, been lost and rediscovered. Taste and fashions change, and artists celebrated now may have only been of limited regional interest 70 years ago, like Schiele, and consequently minimally recorded. Objects may not have been unique, or perhaps the picture was only partially documented by its former owners, for whom noting a Renoir landscape on an inventory or insurance list might have been enough detail at the time. Even with the best will in the world, it's often difficult to offer assistance to claimants who have very little information. It's very rarely the case that we have a complete provenance for a work of art from the point of its execution to the present day, and where we do identify a potential claim, as I mentioned earlier, it isn't always clear who the claimants are, with families having been scattered around the world with the aftermath of after the war. So what happens when we do find looted art? When Christie's receives claims or we identify possible claims for looted art, our goal is to facilitate a dialogue between consignor and claimant and to help find equitable resolutions, often with successful outcomes. Depending on the claim, litigation may be the only way to reclaim Nazi-looted property, but as is evident from the comparatively small number of lawsuits filed on the World War II looted art front, litigation may not always be the most productive avenue for reaching appropriate solutions to these types of cases. And Tom talked about this as well. The emotional and financial costs associated with litigation are high and may indeed outweigh the value of the item in question. And indeed, legal wrangling can often obscure what could be a simple compromise or resolution. Holocaust-related art claims had the unique history that the theft was connected to the murder of millions. This history makes claims highly emotional and often difficult to handle under normal legal standards. So it's most often dialogue which resolves claims. For an unsuspecting current owner, hearing the real story behind his or her artwork can bring about a willingness to compromise. And likewise, a claimant may be sympathetic to an owner who has only relatively recently acquired the work with no knowledge of the true provenance. Indeed, the vast majority of holders of looted art, in this instance our clients, have no idea of its earlier provenance. And therefore, it's often the case with the claims that we handle that you have two innocents, the original owners and the current holder. So while there may be legal principles which can be invoked both for claims and in their defense, it's often much more a moral and pragmatic approach which guides restitution in the art market today. Constructive dialogue, which allows each party to understand and respect the other's position, often leads to fair and non-litigious endings for all involved. This Dürer print is a good case in point. Consigned to Christie's, our research in fact traced it to the collection of the Kunsthalle Bremen, which was significantly looted by the Red Army from its hiding place at the end of the war. We don't know exactly the path which it took, but it was in a private European collection in the 70s. Obviously, the museum was delighted to learn of its rediscovery, but our consignor was initially very upset at learning its true history. However, a compromise was found, and with a nominal goodwill gesture on the part of the museum and the open-minded and fair approach of the then holder, the print was returned to the museum. This work, Peter de Greber, was consigned to us for sale, unsigned and unrecognized and damaged along the way. When Christie's first offered this for sale in March 2006, we did so under the attribution of anonymous 18th century English school. Days before the sale, we were contacted by the Art Loss Register, who alerted us to the fact that they had an image on their database which appeared to match our lot. On closer inspection, it was indeed revealed to be a painting featured in one of the Polish catalogs of war losses, attributed to the artist Peter de Greber. We quickly withdrew the painting from sale, and shortly afterwards were contacted by the Polish government, which was keen to recover the painting. In fact, the painting was not one of those taken from the walls of Poland's museums, although many hundreds were. Indeed, it belonged to art and antiques dealer in Warsaw, Abe Gutnier. Gutnier had been sent to the Warsaw Ghetto after the Nazi occupation of Poland, leaving abandoned his collection and his shop, which were soon confiscated. He and nearly all of his family were murdered in the ghetto in 1942, but his son Ludwig survived. And it was to Ludwig's widow and children that the painting was eventually restituted following 2 years of negotiations between the then owner, the Polish Ministry of Affairs, and Christie's. Both heir and current holder came to an amicable agreement in 2008, which led to the painting's sale. A painting thought lost in the chaos of the war, rediscovered and reattributed and restituted successfully. And to finish, in another case where Christie's was able to assist in identifying an issue and then putting client and claimant in touch through us, involved the Chile landscape Wilted Sunflowers, which before its rediscovery had been lost, presumed destroyed in the war. It had been in the collection of Viennese collector and dealer Karl Grunwald, who, despite the Nazis confiscating his property shortly after the Anschluss in 1938, managed to get his collection of Chiles out of Austria because the Nazis had little interest in modern art. Settling in Paris, Grunwald had moved the 50 works via a shipper to Strasbourg. However, the collection never made it to Paris and was still with his storage company in Strasbourg at the outbreak of the war and the subsequent invasion of France in 1940. The collection was confiscated by Nazi forces in Strasbourg and sold without ceremony, without paperwork or documentation. And included in the collection was the Wilted Sunflowers, and that was the last that anyone had seen of it for about 60 years. After having settled in the United States, Karl spent most of his life searching for his collection, and when he died in 1964, his son Fred carried on the search. Like so many dispossessed families, they didn't give up. Fred had some success, but the one painting that Karl considered the jewel of the collection was the sunflowers, and the search for it was passed down as a legacy in the family. By coincidence, the painting turned up during a routine Christie's valuation in France in 2005. But the delight of our specialists in rediscovering this lost masterpiece was tempered by knowing its true provenance. The then owner had no knowledge of the painting's history, but when he learned of it, he was keen to find a way to return it to its original owners. He asked Christie's to establish contact with the Grunwald heirs on his behalf, and with some negotiation, the painting was restituted to the Grunwald family. The painting was offered for sale, and the matter was resolved. So I hope I've given you some idea of what Christie's does vis-a-vis these issues. We've been privileged to have been involved in many claims, negotiations, and settlements over the years. And in many respects, the fact that Christie's and other big auction houses like Sotheby's undertake this sort of work, indeed that it's central to what our team does, shows how far the art market has come. Thank you.
Thank you, Monica. I suppose this would be a good time for me to disclose that I do have professional dealings both with Monica and with Lucian. Of course, they represent the top of the market and the highest professional standards in this area. I think you can get a sense from what we've been hearing up to now about the complexity of these issues and how they take shape. I do teach a course in cultural property at George Washington University in the School of Museum Studies, and I think of it as a course in decision-making in the face of uncertainty. And I think you're hearing how difficult it is both for museums and auction houses and participants in the market to make those decisions. I'm formulating a question in my mind about who has a greater need for certainty, or who functions best in the presence of uncertainty, museums or auction houses, but we'll see if there's time for that. So let me introduce Lucian Simmons, also trained as a lawyer in the UK, in his case, both as a barrister and a solicitor. He's now the Senior Vice President of Sotheby's. Does come to speak at my class, where he is always one of our favorite guests. So please, Lucian, take the podium.
Well, thank you, Tom, and thank you to the Art Law Society for inviting me here tonight. While I do this technical computer gizmo thing, I should say that Monica gave my speech. So rather than sit down, what I thought I'd do is to give you some, if you like, some snapshots as to what it is that I do at Sotheby's and how different our lives at Sotheby's are to the lives of researchers working in the museum and in the public community. I guess I should say at the start, in sympathy with Sarah, I'm also 25 years in practice. I've been a lawyer for 25 years. Since 1994, I've been at Sotheby's, and I'm still qualified as a UK qualified solicitor. And again, like Monica, my role at Sotheby's really is in three parts. Firstly, it's minimizing the risk that we might inadvertently sell a work of art which was looted but never given back after World War II. Is to work with clients who have potential issues over ownership of works of art in their collections, and also it's working alongside families who lost works of art in World War II. But as I said, I thought I'd stick very much to my own experience in speaking to you tonight, and sticking strictly to pictures which I've worked on since I first started working in this field back in 1997. And I start with this picture, which is a Van Rystel landscape, which was consigned to Sotheby's for sale in the summer of 1997. It was consigned by a family of industrialists based in Germany. And when we took it for sale, we do what we always try to do, and that is to give the fullest possible provenance we could for the painting, working with the documents which the family gave to us. And in this case, what we said for provenance was that the painting had been with the dealer Paul Cassirer in Berlin in 1934. It had then been with Robert Maas, a collector, again in 1934 in Berlin. And then the next line we gave in our provenance was that the painting had been acquired for the museum in Linz in 1941. And then we went on to say it had been in the Paris art market in the 1950s. We thought we'd done a great job for our client because we'd given a really full provenance. But the Boston Globe, Walter Robinson in particular, disagreed with us. And at the same time as he was writing articles criticizing the museums that my esteemed colleagues work in, he wrote an indictment of Sotheby's saying something to the effect of Sotheby's sells Nazi looted art. Because what he'd inferred was that because this painting had been acquired for Hitler's museum, or planned museum in Linz, it must have been taken from a Jewish family, and therefore there must be some kind of a claim or a taint on the picture. Well, the immediate effect of this article for Sotheby's was that we spoke to our clients, withdrew the painting from sale to enable further research to take place. But the long-term effect was that our head of legal in New York, our head of press, and indeed our chief executive, called me and a colleague on one side and said they didn't want this to happen again, and could we please make sure it didn't. And at that point, we drew up a due diligence procedure. Essentially what we did was to say, okay, this is a problem that the auction house faces and a problem the whole art market faces, and what we need to do is to look at it in the same ways we look at money laundering, the same ways we look at import-export issues, the same way we look at endangered species, and try and come up with a series of procedures to minimize the risk that we'd fall into a trap, or more importantly, expose our buyers and sellers to the potential to a claim. Now, before I actually sketch over the kinds of things we do as part of our due diligence, I thought I'd mention that this is a great example, this painting, of how the claims we face are not just legal. I know a lot of you here are lawyers and you kind of want things to be legal, but often the claims which are brought against Sotheby's and Sotheby's clients and Sotheby's clients' pictures are time-barred. Limitation periods have run, prescription periods have run under European law, so there's no extant legal claim. But what you do have is an ethical claim, and you have a claim which, when it's published in the Boston Globe, is sufficient to prevent a painting from selling and is sufficient to damage the reputation of one of Sotheby's clients and, being selfish, to damage the reputation of Sotheby's as a publicly quoted company. So you have legal claims, you have ethical claims, and I guess you have marketability claims as well. If you have the potential for a World War II allegation being made against a painting, then it damages the market price of that painting. So there's a commercial element to this as well. So when you look at these issues, when you're reading books, when you're reading cases, always remember it's not just the legal aspect, it's more complicated than that. So very briefly, what I thought I'd do is to tell you what we do at Sotheby's to try and avoid claims happening. And really this tracks quite closely what the American Association of Museums have recommended for museums here. The main difference being that they're doing their research over a period of months and years, whereas often Sotheby's and Christie's are doing their research over a period of maybe a few weeks or even days when collecting goods for a sale and when preparing a catalogue. Very easily, the first thing we do is to ask the client where the painting came from. It's kind of obvious, but it's surprising how often a client who's selling a painting will have invoices, will have some idea by repute as to where a painting came into the family's collection, or even, as in this case, actually has a photograph showing where the painting hung in their family's house. This is actually an example of a painting which we have coming up for sale in January. It's actually a restituted painting. But the image you see on the bottom right of this slide is the painting hanging in the collector's family home in Berlin in the 1930s. And this is actually one of the main parts of proof which the family used in persuading the Wallraf Richartz Museum in Cologne to restitute this painting to them earlier this year. The second thing we do, again, very basic and very obvious, but it's following a set procedure which minimizes risk. We look in all the textbooks, all the catalogues raisonné for the artist, and indeed on the people who used to own a painting, trying to build the most full provenance or ownership history we can from all the sources available. This is an example of a painting which we have coming up for sale in New York in 2 weeks' time. It's a Cézanne. And in this case, in trying to make sure we tied down the provenance, because this had actually once belonged to the German collector Edward Arnhold, whose collection was looted by the Nazis, we wanted to make sure that we knew exactly where it had been and that it wasn't one of the paintings which had been stolen from the Arnhold family. And in the process of this, we found this image in the bottom right of this slide showing the Cézanne in Edward Arnhold's house in the very early years of the 20th century. And we also found proof that he actually paid 33,000 marks for this painting on December the 17th, 1911. So basically, that's the kind of exercise we're going through, trying to pull together public sources to create the provenance. The third thing we do, again, it's obvious, it's to look and see if there are any physical signs on the work of art which might indicate where it was in its past. And I realized as law students, you might not know what the back of a painting, like an important painting, looks like. And this, just as an example, is the back of a still life by Léger, which we sold in London earlier this year. And you can see the labels on the canvas at the bottom, and on the left on the stretcher, and at the top on the stretcher. And although I realize there's no way you can see them from where you are, the one at the bottom says this was exhibited in the Galerie de Sturm. One at the top says that it was exhibited in the Gallery Kahnweiler, which is a gallery both before and after the First World War. And on the left, there's the label from the Gallery Alfred Flechtheim. And those three labels together, even without any publication history, enable you to start putting together a provenance which can show you when and where that painting was in its past. And occasionally, actually not so occasionally, you find this kind of label. And this is a label which relates to the Linz Museum and the Linz inventory, which Tom showed right at the beginning of our session tonight. And when you find one of these labels, you can then go back to the records and see whether or not this painting was taken from a Jewish family, and hopefully trace whether or not the painting was ever restituted. Having done those very basic checks, what we'll then do is to use our database, which is very similar to the database which Christie's has, which Monica mentioned, which sets up red flags or indications that a painting might have been in the wrong place at the wrong time with the wrong person. And we also look at our internal archives, which we've been building over the last 11 years of our restitution department, looking at World War II catalogues and so on. And then after all that's gone on, then we will have our catalogues checked by the Art Loss Register, which again Monica mentioned, and we'll send them out as gratis copies to all the organizations worldwide which focus on this area. And the whole idea of this is to flush out claims and to identify claims before we might accidentally cause injury or cause a claim to our buyers or our sellers. Well, Monica's already covered what happens if there's an issue, but again, I thought I'd give you a couple of concrete examples from our Sotheby's recent sales, which show the kind of research we do. This is a painting by Semole, which came in for sale through one of our Italian offices at the end of last year. And the head of our Old Master Department in New York came to me asking for help, because the only provenance we had when this painting came in for sale was Private Collection Hermann Goering, Munich, thence by descent. Obvious the conversation went place, and we can't sell this, can we? No. But then he said, could we kind of investigate and see whether that provenance was true? So we then went through a process of going through all the books on Hermann Goering's collection. There's an incredible expert who works in the National Gallery here in DC, who is doing a catalogue of Hermann Goering's collection, so I called her. And I couldn't find this painting anywhere. There was no sign that Hermann Goering had it. So eventually I called a lady called Ilse von der Mühlen, who works in Bavaria in the Munich State Gallery, to say, did she have any record of it in Hermann Goering's collection? And she said no, but she did have a record that was sold in the same sale as some works which he had owned. And to cut a long story short, we discovered that this painting had actually not been with Hermann Goering at all. It had belonged to a German aristocrat called Albert Schrenck-Notzing, who, amongst other things, was the first man to photograph ectoplasm. And they lived in this palace on the left of this slide. He died long before World War II and left it, along with the palace, to his widow. His widow was an ardent Nazi and sold both the palace and all the paintings in it at a discount to the Nazi Party as an extension for their headquarters. So essentially, the provenance went Schrenck-Notzing, the Countess Schrenck-Notzing, the Nazi Party of Germany. Then after the war, it was restituted to the Bavarian state. They gave it to the Bavarian State Gallery, and then that sold it to, in fact, our consignor's predecessor. So we were able to offer this for sale with that full provenance set out in January this year. This is another example, quite similar to some of the ones which Monica mentioned when the story was not so simple. This is a Juan Gris painting which came in for sale about 4 years ago in our London office. And we identified a potential issue because it had once belonged to Alphonse Kahn, who was a famous dealer collector living in Saint-Germain outside Paris in the years before the war. After 3 years of research and negotiation between the Kahn family and their lawyers and our consignor's lawyers and Sotheby's, we never actually managed to work out whether this painting had been looted or restituted and what his exact history was. But the very presence of Alphonse Kahn's name in the provenance was such as to put off any potential buyer. So a deal was done between the Kahn family and our consignor, which essentially enabled the painting to be sold pretty well, in January last February. And this is really an example of the commercial world trying to help people to reach a just and fair solution. Just and fair is the phrase used in the Washington Principles. They don't actually apply to auction houses, but when we approach these issues and when we deal with consignors and their attorneys, when we deal with claimants and their attorneys, we always have this in our minds as a means of trying to bring people together, bearing in mind, as Monica said, that there are often two victims. This is really just in here as a slide to fuel questions, in case none of you have any other questions. This is the footnote which you often get in catalogues from Nazi Germany. Basically, when in the front of catalogues, you'll often have a list of prior owners who are identified by initials. So it'll say lots 1 to 20 in this catalogue, K Berlin, and that's all you'll know. But then you'll have a little asterisk next to some of them, and then at the bottom of the page it'll say former non-Aryan collection, which is what this means in English. And one of the questions we have come up twice a year, maybe once a year, is what do you do if you know that a painting was sold in Nazi Germany in a catalogue, and the painting was designated as formerly Jewish property, but you don't know who the former Jewish owner was? In other words, what do you do when you have property which you believe was probably looted, but you have no claimant, you have no opponent, you have nobody to enter into a discussion with? So that's just a question for you to ask later, in case you don't have any others. And again, this is picking up on a point which a couple of my colleagues made. We're not just dealing with claims brought by the heirs to Jewish collections. This is a painting which came in for sale from our Tokyo office at the end of last year. And when it came in, we identified that it had been in the collection of Henry Newman of Hamburg. Henry Newman was an Aryan. He wasn't Jewish, but he was a leading banker in Hamburg at the beginning of the 20th century. He died shortly after this photograph was taken and left his collection, including all the pictures and paintings in this picture, including the Degas to the left of the fireplace, to his widow. And come the escalation of hostilities in World War II, his widow placed the collection in storage with the Deutsche Bank. This Degas, along with the rest of the collection, remained in Deutsche Bank in the vault until approximately 1945, when Russian soldiers took it and the other paintings. The painting then landed up in the Metropolitan Museum of Art as a gift in 1982. The Met then sold the painting through Sotheby's in 1986, where it was purchased by our Japanese client. And basically what then happened was we treated this as we would treat any other World War II claim. I contacted the Newman family's lawyers. I contacted the Japanese clients, helped them to find a lawyer in Tokyo, and then, not acting as a mediator, but if you like, acting as a facilitator, sort of tried to guide them towards a dialogue, which after about 3 weeks succeeded, and they agreed that the best way to solve their differences was to consign this to Sotheby's for sale in our February auction, and split the proceeds in a way which they both felt was equitable, given their legal, their ethical, their PR, and their negotiating interests. So basically that was a successful outcome for both sides, because the owner converted what's been described as a pariah work of art which he couldn't liquidate, an illiquid work of art, into a successful sale, and the Newman family also managed to resolve their claim. This is, I'm afraid, gratuitous. This is the main picture in Sotheby's upcoming Impressionist sale to take place on Monday week, and it's a Malevich. This was actually one of the same batch of paintings which Sarah showed earlier, one of which had been at the Fog. This picture was entrusted by Kazimir Malevich to an associate in Berlin when he had to flee back to St. Petersburg in 1927. The associate then sold it to the Stedelijk Museum in Amsterdam in 1958, along with dozens of other works of art by Malevich. And earlier this year, this painting was restituted by the Stedelijk to the Malevich family. And again, as Sarah mentioned, there are over 30 members of the family. So in order to equitably deal with their inheritance, they've asked Sotheby's to sell this, which we will be doing on the 3rd of November. But it actually, apart from the gratuitous showing of the image, it is also an example of how restitution has spread, and it's not just Nazi cases these days, but also includes works of art which went missing through other routes. And finally, I was going to mention one other thing which has changed in the 10 years I've been working in this field. It was already touched on earlier, and that is there's an increasing tendency of people who receive claims from people who allege they were the victims of World War II looting to aggressively assert their rights through litigation. You saw an image earlier of the Van Gogh, which is in Detroit, which is the subject of an action for a declaration that a claim was invalid, made against the Nathan family. This is Sotheby's example. This is a painting or a watercolor which was consigned for sale by David Backlar from here in Boston, consigned for sale in 2004. He received a claim after the sale from the heirs of Fritz Grunbaum, who was a Jewish cabaret entertainer in Vienna. And he contested the claim on the basis that Fritz Grunbaum's sister-in-law had sold this painting voluntarily in 1956 to the dealer 2 up in the chain from him. And he won his case in the Southern District of New York earlier this summer, and an appeal was actually lodged last week to this case. So this is an example of the increasing amount of litigation which is occurring in this field, and also the increasing aggression of the recipients of some claims when they feel that the claims being brought against them are without merit. And really, finally, I thought I'd leave you with this, which is an example of just how far we've come since 1997, when numbers of us on this panel started in this field. And this is a slide which comprises numbers of stamps and seals, which I've seen at Sotheby's in the last 4 or 5 years. And the thing they all have in common is they're all fakes. These are all fake Nazi seals, which people have put on the backs of paintings in order to try and convince art experts that the works of art are real. So people are assuming a base knowledge that a Nazi stamp is bad, and that people could recognize these stamps, and are then using it to try and convince us that the works of art concerned were created prior to 1940. So it's a complete turnaround. We started off 10 years ago with kind of a miasma and a general lack of knowledge, well, some people did, in this area. But now it's turned right around. So now you've actually got people saying a Nazi provenance is a good thing because it shows a work of art isn't a fake. Thank you.
Well, thank you very much, Lucian. I think we've had a lot of complexity and uncertainty for one evening, but now it's your turn to see if you can stir the mix a little bit. We have microphones on both sides. If anyone has questions, please come on down to the front and feel free to ask one.
Yes, hi. Mr. Klein, you had noted earlier that there had been a lack of interest, for lack of a better phrase, in the 60s towards attempts at making restitution of these artworks, and that this has picked up recently in the last 15 or so years. And I'm wondering what you all see as the future of this in the next 15 to 20 years. Do you see this as something that is going to become more and more contested, or do you see this as time goes by and as more and more time becomes put between the present moment and when this happened? Do you think that there will be less instances of this contention, or do you think that the passage of time and the perhaps passing away of people, the forgetting of events, is going to lead to just more intractable attempts to I've lost the end of my sentence. I'm very sorry, but I think you know where I was going with that.
Sarah, do you want to comment?
I think if you'd asked me 5 years ago, I would have told you I'd be done doing this by now. And I think that what's happened is that not only has our access to documentation changed, but the legal market has changed too. And so some of those claims that current holders are reacting against so aggressively, in Lucian's phrase, have to do with the fact that that the people who are, the claimants aren't even aware that there are objects in their families. And so claims are being brought where people don't really have a direct connection to the object. And so there are more, the claims are sort of spreading, and there are lawyers who are specializing in finding claimants and then bringing them to objects. And so I think that the field is changing. I mean, the Bacalar case is one of those, really. The lawyer, I think, who represented the current claimants initially represented someone in the case at the Museum of Modern Art, and that person turned out to actually not be a claimant. They didn't have a direct connection to the original owner, and they did the genealogical work to find these people and inform them that they might be claimants. But they're moving forward without a lot of knowledge of what was in the collection. So I think as the legal field changes, the kinds of work that we're doing changes too.
Other comments?
I mean, just to follow up on what Sarah said, mentioned, the reality is, I mean, after the war also, it was just very difficult for those direct survivors to pursue these claims and focus on recovering property. And what you're seeing now are more claims, but also it is easier. You're seeing second, third, fourth generations pursuing these claims. They're more distant from the emotional sort of horror of the event, and they want to learn about their grandfathers, great-grandfathers, their families, and they are more interested in pursuing these claims. You also have, I mean, there's lots of artwork out there, objects that have not been recovered yet, so there probably will be a lot of claims to come, no doubt. I'm sure that
Basically, I agree. I mean, I'd expected, like Sarah, to be doing something completely different by now, but it's almost growing as a field. And most of the claims, I don't want to give the impression that claims are specious. Most of the claims are completely genuine. And as Monica says, there is a third generation effect, where the first generation who escaped from Europe were building their lives in the States or in England. Second generation were consolidating, and the third generation are thinking, what happened when what happened to our inheritance? And then they start questioning, and that's when people start to realize that they do have valid claims.
Yeah, I mean, and having said that, there are sort of genealogists, historians, all kinds of people sort of entering into this area, and unfortunately, there are some claims being made that perhaps should be researched a bit more before those claims are made. It really is all about sort of. I mean, the problem is, again, as you've heard, it's you don't have most often you don't have 100% of the documentation, so you do have to sort of make decisions in a bit of a vacuum, and it's a judgment call.
Thank you.
Okay, over here.
Hi. I think all of you impressed on us the complexity of the situation. I was wondering, stepping back, if you could just give us kind of a simplified legal rule on the rights of claimants and on current possessors of art.
I knew I should have brought that slide. The basic black letter rule is that a thief cannot pass title. So the bedrock issue in any case is can it be established whether a particular object was stolen? That entails the issue of initial proof. Perhaps the object was not photographed and it fits a generic description like Sarah was talking about, or perhaps it was the subject of some kind of a forced sale, where we don't really know the facts, like the Toledo and Detroit cases where maybe it wasn't necessarily coerced, and we haven't had many of those cases, so we don't have a good standard. First black letter rule is it the same object that was stolen from the original possessor? And then for simplicity's sake, we just say issues related to the passage of time, statute of limitations and latches, which are critical issues in this country. And the dominant rule in the United States is called the discovery rule. There are 50 different rules, but the dominant rule is the discovery rule, which is sometimes called the due diligence rule, because the basic notion is that if the victim is diligent, then the statute of limitations does not begin to run. So we heard comment before, and really all of these cases, we have issues related to the passage of time. Has the statute of limitations passed? And Sarah mentioned that statute of limitations is sometimes thought of as a technical rule. Now, those of you who are law students know it really enforces substantial legal principles about repose and the ability of people to put things behind them and investment-backed expectations and all those things, or balancing the rights of people to preserve their claims versus the rights of other people to have claims die off eventually. The original notion, I think, back in the late 90s was, well, maybe if there's only a statute of limitations defense, and which could be hard fought, then if we view that as a technical defense, then maybe a museum ought to settle a case if it's otherwise a strong claim. And I think what we've seen in the Toledo and Detroit cases that Sarah talked about is there are multiple issues related to whether there was a theft and also passage of time. And I would say from discussing these cases frequently, really, let's say a third concern is just that the lack of documentation. You almost never get the whole picture. Some of the stories that Lucian told in particular, you got the exact picture. You knew exactly what happened. A painting had been restituted or it was a different painting. But usually there's something missing. The art is with someone. That person has an unhappy end, and we don't really know what happened to the painting. What conclusions can we draw? Is it more likely that there was a friendly transaction or more likely that was a theft? And that's the kind of case that we usually settle.
And excuse me, I also just wanted to know, when you said that there are two victims, and going on that idea of sort of an agnostic, like we just don't know, we fundamentally don't have enough information as a general rule, are there certain sort of informal burdens of proof or presumptions that are made for one side or the other in these negotiations? So not in a straight legalistic sense, but just, it is a very emotional issue, and it seems like it could be influenced emotionally, maybe.
Yeah, I'm going to pass the question in a second, but something that you may not hear in this building is the law is a blunt instrument. And the people go to court, and the court process is worse. The court, in a Raplevin case, can only give the object to one side. It can't reach a just and fair solution, and that may be fair, may not be. I think, so that's why these cases lend themselves to mediation and negotiation, and why better results can be achieved through negotiation, which we've heard about a lot tonight. But does somebody want to comment on the two victims? Lucian, I know you mentioned it, and maybe Monica too.
Yeah, I mean, I always feel very guilty saying two victims, because the heirs of a Holocaust victim are very different to people who paid good value for a painting in Madison Avenue in 1970. But in a way, they are both victims, because the bad guy or the guy who stole the painting is long since dead or was unlocated. So that's the sense in which there are two victims. So what I spend a lot of my time doing, and I'm sure Monica's the same, when you're speaking to two attorneys acting for a claimant and acting for the current owner, you're trying to explain to them that each one has to give, because the facts are often very foggy or inconvenient. And so you're saying to the heirs of the victim, yes, we know you lost it, and yes, we know your family suffered, but you can't ignore the passage of 70 years and other owners. Maybe there have been transactions in jurisdictions which have expunged title. And to the other side, you say, yes, we know you have legal title, but you don't have marketable title, so you have to move the other way. So often what you're doing is you're apportioning risk in strict legal terms.
And in terms of a museum, if you can't determine what happened, you can't make the decision to deaccession the object based on, a good chance. Deaccessioning an object is, as Sarah talked about, a serious decision, and sometimes there's simply a lack of evidence either way.
When you talk about deaccessioning for purposes of settlement.
Yes, exactly.
There's an additional issue there, which is if a museum wants to deaccession a piece and it's not sure it's the owner and it wants to do something with the piece, it has the additional problem, how much uncertainty it can tolerate on whether it can take the piece to market or move it to another museum or something before it establishes what the real ownership is. Beth, do you have a question?
Yes, I actually have a question for Monica. In the case of the Albrecht Dürer print that you were talking about, how did you determine that that was the exact print that, you know, was owned by the claimant. In the case of prints, there are multiple copies. So how do you go about evaluating that type of claim?
It's a very good question. And my researcher is the one who identified, identified that print, and it actually took quite a while. But that's a great question. But I don't have an exact response that you'd be satisfied with. But
and I have another question for the panel. I know that there have been some recent exhibitions of unclaimed artwork to try to get claimants to come forward. What do you think about that process, that role that the museum takes on to ask claimants to come forward?
Do you mean the exhibition in Israel?
Yes, I think
year?
there was one in Israel, and there was also one in the Netherlands, I believe.
I mean, that one's really complicated because those are objects that were deemed airless once already and then were given as a sort of restitution to the Israel Museum. So they've already been used for restitution once. So, I mean, I was there and looked at some of the objects a year and a half ago. And a lot of them are objects that people are unlikely to be looking for. Some of them are just very personal and not very valuable. And those things people might really want, but they're hard to find because they're not published. And a lot of them were sort of reproductions and things like that. It's you have to look at also the cost to the museum for doing that. I'm not sure what the outcome of that exhibition will be. You were at the conference in Paris,
Yeah.
right?
Yeah, and also the one in Israel where they showed some of these objects of Judaica that are very hard to trace. That's what you're talking about. But there's also this problem that I mentioned that European countries have of art that should have been restituted at the end of the war, but there was no one to restitute it to, and it's stayed in museum collections. It's not a problem that we have here, but it lends itself more to the kind of solution that Beth was referring to. I should be asking, could you identify yourself and ask your question?
My name is Charles Delheim. I'm not a law student. I'm not a lawyer. I am the head of the history department at BU, so I suppose I have some claim to be here.
Well, welcome.
So may I? Can I make a couple of comments just to make things still more complicated? First, on this issue of the exhibition which took place in Israel, there was an exhibition after the war in the Jeu de Paume, which was put on by the Commission de Récupération Artistique, which had some success in finding claimants, but it's a lot more complicated than that. So may I just begin with what you said, Mr. Klein? I mean, first, let me just say that I thought Joel did an excellent job and taking some very complicated issues. But in terms of the chronology, what actually happened after the war is a lot more complicated than you made out. And it wasn't simply the immense problem of the survivors worrying about their own survival. There were also problems of documentation. But there were problems still more of the national commissions. The national commissions were formed by governments which had been occupied during the war and whose own roles had been, to say the least, murky and to say the most, collaborationist in certain respects. And it's still very difficult to get access to the French records of the Commission de Récupération. And the argument used by the French government is that these are privacy laws. Well, you can say that they're privacy laws, but the privacy laws protect what the French government did and did not do. I think that in terms of the chronology of this, in fact, there's an immediate flurry of interest in looted art after the war. And this flurry is, to a very large extent, dies down when the commissions are disbanded. And almost all of them are disbanded very, very quickly, embarrassingly quickly. So I think that, while you're absolutely right that there were claimants, Paul Rosenberg, for one, and then his family, who carried on claims after the war, there was an enormous amount of stonewalling which took place. And the situations of national governments were different. Second, I mean, I think it's absolutely right that journalists have been sensationalistic and seizing stories. But let's face it, there were stories to seize. And you raised Walter Robinson. I mean, the reason Walter Robinson and other journalists are important in this story, and there are Austrian and German journalists who are also important, as you know, is because institutions like the MFA were, if not purposely blind, functionally blind to what happened at shows like the Monet in the 20th Century exhibit. I mean, it wasn't simply that museums and dealers had been doing their jobs until this time, and a few things slipped by. Third, on the point of the two innocents, I agree. There can be two victims, but it's not true that there are always two victims, and the closer you get to the period after the war, you had a number of people, and I can tell you several eminent London art dealers speaking to me off the record, one of whom was an old family friend, said there was a lot of awareness on the part of people in the trade after the war that something which slipped off a truck in Paris or Munich and appeared in 1946 or 1947 was not there by accident, and that these gaps in provenance research and the gaps in provenance, which probably wouldn't have happened in old masters but did happen in modern art, were things that the art trade turned away from quite knowingly, as did museums in certain cases. So without being overly moralistic and without detracting from the wonderful work, and I really say this sincerely, that you've all done, I mean, I think we have to admit here in terms of a historical account that there was a problem, and it was a problem which came to the fore in the mid-90s for a lot of complicated reasons, not the least of which was the growing consciousness of the Holocaust in American culture and in Europe. So I've spoken way long enough, but done.
Thank you. Any responses?
Well, I mean, I'll make one, but trouble is you man are making comments at each other all night. But it is, the bottom line is, the more we all do this, you realize that nothing is black and white. Everything is gray. So, for instance, you have the dealer Paul Grauper, who 10 years ago when I started was demonized as being the man who looted all the Jewish collections in Berlin. But then, 6 months later, you learn he was Jewish and he was obligated to do that, and his own collection was looted 6 months later and was looted again in Paris. And then when he got to New York, he was helping rescue people and helping get money out for Jewish friends. And then you go back to the fact, yes, but then he was selling property that belonged to Jewish families who didn't escape. So you just get in a spiral of confusion, and the bottom line is it's gray, and a lot of people were doing things just to survive.
Fair enough.
Well, yes.
Sorry, just a quick one. This is
And you are?
my name is Ben Nerdick. I'm a second-year law student. And one of my understandings is that with the third generational effects that were mentioned fairly recently was one of the sources of information that's being used to try to get information from these claims has been insurance policies and insurance records. And one of the problems has been that these records have been either hard to find, or where they have been found, they haven't been released, they haven't been made public. And in America, I know there's been a lot of legislation, legal battles over trying to force these records public, make sure that these things are made public to the courts, to the victims' families. And one of my questions was, A, how important are these insurance records actually in determining the provenance and the history of this art? And second, what your organizations are doing, if anything, to work with these insurance companies or work with politicians or organizations to make sure that these records come to light or become public.
Monica?
When I was at the Holocaust Claims Office, I worked on a number of these Holocaust-era insurance claims. And the issue is, I mean, to generalize, apparently life insurance policies were kept, I mean, and kept for longer than 10 years. They always said 10 years, but actually a lot of the insurance companies did keep life insurance policies. And a lot of these companies actually still have those records. With regards to insurance policies on objects, apparently those were yearly policies. Again, I'm generalizing. Yearly policies, and those records were not kept. There's absolutely, I think there was a lot of effort to try to get a hold of some of these sort of insurance records relating to objects, but they just simply, apparently did not exist. And those policies were yearly policies, yearly products. That are just simply not available. I mean, yeah.
And in answer to your question about their usefulness, again, it really goes back to how carefully described the objects are. If they're sort of generic descriptions, then it's not so helpful. If it's really specific, it's terrific. And Sophie Lilly's book relies really heavily on insurance policies for a lot of the lists that she provides.
And you are?
My name is Martha Clausen. In interest of full disclosure, I'm an employee at the MFA and also a student here at BU, a graduate student in art history. Approaching this topic as an art historian, I'm wondering, I get the impression that when claims are launched and the decision is made that something should be returned, often the heirs go on and perhaps keep it for themselves or perhaps turn to the art market and sell objects. And as someone who's interested in access to art, I'm wondering if you could all speak to that issue.
Do you want to start? I mean, you have to remember just the practical aspect is lawyers who help you get art back charge money. And people who have claims might not have collections and wealth. And so they might not have another option. They might have to sell it. There might be 31 heirs, and there's no way to divide the painting 31 ways. So in a lot of cases, there's not really another option but selling the object.
One of the things...
Unless you want to give it to the museum, which does happen sometimes.
It does.
But,
yeah, I mean, there are different ways to settle a claim, and if you decide that you are going to restitute it, it's ultimately up to the person who receives it to do with it what they want. And does it make a difference what they're going to do with it? It really shouldn't. If you determine that it's their property, then it's their property. But if you find out that something in the collection was, for example, at the MFA, we have a little Giaquinto painting that was sold in a forced auction in Paris in the 40s. And I think it's much more common for a museum to settle financially with a claimant. And the painting remains on view, and similar resolutions were reached with Chicago and with the Princeton Art Museum with the same family, so that the paintings could continue to be enjoyed. The family recognized that these institutions purchased them in good faith, wanted them to remain on view, but also wanted an acknowledgement of the losses that their family suffered. And at each institution, I believe the credit line was changed to reflect the provenance of the man whose collection it had come from.
Yeah, and it can work the other way as well. I've worked on 2 cases in which objects that were not slated for museums ended up in museums as part of a settlement.
Yeah, similarly, the case involving sort of the Lucas Cranach at North Carolina Museum of Art. Again, it was painting. The museum had decided to return it to the heirs. They made that decision without facing litigation, and the heirs were grateful and actually decided to convey sort of half the value of the painting back to the museum. Basically conveyed half the value of the painting back to the museum as a gift. The museum got the painting, and the heirs were compensated, but essentially they were keen to sort of leave that painting in the museum with, again, a plaque sort of describing the provenance and what had transpired.
And then the last comment is that just because something's sold at auction doesn't mean it doesn't land up in a museum. So we sold a Donatello from the Houtstukker collection, which went straight to the Kimball, and the amazing Cornelis van Halen, which Monica was involved in selling, is now in the Met on loan. So things actually do go from private possession into public display as part of this process. But it's kind of random when they do.
Professor Epstein, is it?
Well, hi, I'm Drew Epstein. I'm a lawyer, and I graduated from this law school about 37 years ago, but who's counting? And I have an art law practice here in Boston, but I'm curious, especially to Marcia and Lucian, what happens when you get a consignor who wants to consign a work to you that you have some suspicions about, but you don't have proof that it was Nazi confiscated art? And you just cannot reach a just and fair conclusion to talk to the consignor in an attempt to make restitution to a family where it might have been confiscated. You're publicly traded corporations, and you have a duty to consignors to keep private certain information that you get. And if you can't persuade somebody to come clean with the artwork, say they come to Sotheby's and you raise some questions, can they turn around and go to Christie's with the same work of art, or even to a lesser international auction company? I mean, you have some, I guess, ethical and moral decisions to make as business people. I just wondered how you handle those particular claims.
We can't discuss this apart from in front of witnesses, so we can do this now.
Can we say they do the best they can?
Basically, there are kind of two answers, two parts to your question. The first part, we have a due diligence process, and I think Christie's do too, to try and isolate whether or not there is indeed a problem with a work of art. And that's a process which is based on the work of art rather than on the individual consigning. If we believe, as a result of that research, that there is a possible claim to a work of art, whether or not we can identify the claimant, then certainly at Sotheby's we will inform the consigner very fully as to the result of our findings. If, for instance, we happen to know that the claimant is represented by Tom Klein's firm, then we will push them really quite hard to call Tom and to try and reach some kind of a resolution. And I'm not saying we're good at pushing our clients, but I think in, say, 90 to 95% of cases, we're successful in getting our clients to face that decision now and actually make the call. We'll say things like, do you want to leave this issue to your children? Do you want your children to have to deal with this as part of your estate? What are you going to tell your insurer? What's the value of the painting? We'd argue it's zero. You can't lend this to a museum. If you take it across the French border, it's arguably subject to seizure. So you make all those arguments as to why they should face the music now and why they should enter into a negotiation. Okay, they don't all do it, but most do. Monica?
Exactly same experience. Friendly persuasion, but it works.
Can I ask what you do if they say no? Does the painting just go back? It's something that we're starting to think about in terms of objects that come in that are proposed gifts. Do we have an obligation to contact the authorities if we think there's a problem? We don't really know the answer to that question.
Well, certainly, there's an argument that a consigner who's received a long written report from me or from Monica explaining the problems with their work of art is acting in something approaching bad faith in going to the other auction house with the same object without disclosing that. But one of the things that certainly impacts on my approach to these issues is whether or not there's a claimant. Often, like the former non-Aryan collection, you have a really bad feeling, but there's nobody to speak to. And then that's a very different situation to when you know that a work of art belongs to, say, the Rosenbergs, who were mentioned earlier, when you know that there's a lady sitting in the Upper East Side.
You can call Elaine.
Who you can call.
Other questions? Well, thanks to the panel for coming out and thanks to all of you for your interest and attention.